thank all of you for being here today. We have two bills on the committee, on the agenda, committee's agenda. Nobody has signed up. It's probably not a bad thing. Let me. Somebody who wants to talk? Okay. A couple of housekeeping things. Today is what, day 32? You don't know.
It is.
32?
It's 32.
Tomorrow's 33. We come back in on the 10th. Is that accurate, Diane? Which will be day 34. Does the committee have, and this coming in on Tuesday's thing is cutting us out of a day. Does this committee have an objection to coming in on Monday afternoon, the 9th, for a full committee meeting? You have an objection? In the afternoon. 2 is what I'm thinking. Well, let's do that then. We've not had late meetings yet, Chairman Franklin, as compared to years past. Have you noticed that we have not had late committee meetings?
Stacy says we don't talk about it, maybe we won't. We got to break her in, Mr. Chair. That's not fair. She needs to.
Yeah, I promise I'll do one for Stacy. The chair also, though, wants to see how the process develops. My colleagues in the former body that I love so much, I do hear, I'm very protective of my committee members, and I hear troubling things about some of their bills over there. So would y'all look around and go back and check on things for me? Give me a report, maybe?
Yes, sir.
I want to make some subcommittee assignments also while we're here. Do you have a meeting scheduled, no. Vice Chairman Mumford? I wonder if Chairman Knox has one.
He has one for tomorrow.
That's what I thought. Upon adjournment?
Upon adjournment.
Okay.
Has one bill on it.
Which one is that?
It's the bill about if you don't make an objection at the time of trial to a jury charge.
Whose is it?
You've waived it forever.
Who's the author?
Hamrick.
Who? Hamrick.
Hamrick.
Is he in the Senate?
He is, sir.
No, I'm only teasing. That's good. Okay. Senate Bill 62 will be assigned to Chairman Knox's subcommittee, number 1. Senate Bill 100 by Senator Pearson. I'm putting in subcommittee 2. Senate Bill 139, I'm putting in subcommittee 1. Senate Bill 182, I'm putting in subcommittee 2. That's by Senator Wiles. Senate Bill 190, I'm putting in subcommittee 2. I had previously assigned Senate Bill 203 to the Knox subcommittee. Is he hearing that tomorrow, Diane?
There he is, Chairman.
Are you doing 203 tomorrow?
We did that.
Subcommittee? You've done it? Okay.
No, let's see. We have one left. Is that Senator Hamrick's bill?
Yeah.
Yeah, I told him tomorrow.
Okay.
We just ran out of time for that.
All right, that's fine. Senate Bill 272 be assigned to Subcommittee 1. And Senate Bill 276 will be put in Subcommittee 2. And there are other Senate bills here. I just haven't had time to read them yet. I'll do that next week. Senate Bill 272 in Subcommittee 1. Do you need to read that one first?
No, I just.
Okay. And you're still reviewing Senate Bill 40, aren't you?
That is a good bill. It's ready to go.
Okay, well, Senator Staton is here today, so do you think it's sufficiently been reviewed that we can put it in a subcommittee? Okay. Then we'll put that one in Subcommittee 2. So, had a good day so far, Senator. All right, I'm going to take these in reverse order. Let's call Senate Bill 95 with Senator Carter.
Thank you, Mr. Chairman. Do you have me present from here?
That's fine. Do we have anybody to speak on this one? Thank you. I was looking for you. Thank you for being with us.
Thank you, Mr. Chairman. Members of the committee, always a pleasure to come before you with legislation. Senate Bill 95, very straightforward measure. Essentially, it does two things. It deals with the issue of tobacco products and those who attempt to use tobacco products who are under the appropriate age to use those. Section 1 of the bill really clarifies existing law, and what it addresses is an attempt by a minor to purchase tobacco products. What we're hearing from retailers is that there really is no specific verbiage, no specific language in the law that says an attempt to purchase tobacco products is a violation of the law if you're under 18, much as an attempt to purchase alcoholic beverages. Of course, you know that any attempt to do an act, if completed, that attempt in and of itself is a violation of the law, but that's sort of difficult for retailers to message. And so what they've said to us is, what happens is someone who's underage will repeatedly make these attempts, and we don't have a way to say the law says if you attempt to purchase it, it is in fact a violation of the law. And so they've asked us to go back in and add this language, which is shown in Section 1, that clarifies that an attempt to buy tobacco products if you're underage is in fact a violation of the law. Section 2 deals with a situation that we've begun to see where, not in this state, but we don't want it to happen in this state, where tobacco products and non-tobacco products are combined and sold from the same vending machine. In moving this legislation through the process, we've spoken to many of those who are affected, and even those who represent the tobacco industry, who say, you know, that's not a good thing, and we don't think it's a good thing. Tobacco products are products that are provided for consumption by adults, those who are over the age of 18 and can make those decisions for themselves, and we don't want that to in any way be on the same playing field with candy bars or chewing gum or things that are not tobacco products. So it prohibits those from being sold from the same vending machine. The violation, the penalties for the violations of Section 1 or Section 2 are the same as are in existing law. The penalty provisions do not change. If you attempt to purchase tobacco products and in fact a case is made against you, I'm not sure how often that would happen, frankly, Mr. Chairman, but if a case is made against you, then the court can punish you with up to 20 hours of community service or a lecture at a public lecture on the hazards of the use of tobacco, or a combination of the two, and that's already in existing law, so we didn't change that. The provisions as it relates to a vending machine is that the first offense of selling these products from the same vending machine would result in a fine of no more than $300, and then thereafter be treated generally as a misdemeanor, which would allow a fine up to $1,000.
Thank you very much, Senator. Questions from the committee? Representative Byrd and then Chairman Franklin.
Could you tell me how many cigarette vending machines around the state? I don't know that I've seen a whole lot lately.
Yeah, there probably are not a lot. I know that before we started working on this, I didn't pay attention. I didn't know where there was a vending machine, but there's one in the apartment building where I stay here in Atlanta. So there are some vending machines around. We have a specific statute that addresses where those vending machines can be located in establishments where only those 18 or older are allowed, in retail establishments where the machine is in plain view of a clerk or cashier. I know that there is in my town there is a shoe repair business, and there's a counter there, and they sell boots and they repair shoes, and over to one side is a cigarette vending machine in plain view of the counter, close to the counter, in fact. And I assume that's because the person who operates that doesn't want to be in the business of selling cigarettes, but they provide that for their customers. I think also in roadside rest areas there's some narrow exceptions as to where they're allowed. Now those vending machines have to have displayed on them a sign that says you cannot purchase these tobacco products unless you're of the proper age. And I'm not suggesting that it necessarily stops those who are not, but that's the current state of the law as it relates to vending machines.
May I have a follow-up question?
Sure.
So these vending machines, wherever they may be, who is going to, is someone going to check someone's ID, whether they're 18 years old before they purchase these, puts their money in the vending machine? Or how is that going to work?
Well, no, I'm not suggesting that at all. And one of the problems I think this addresses is the fact that the current law and the number of places where you can have a vending machine, the current law would be even harder to enforce if we don't say the only thing that you can put in that machine is either tobacco products or the only thing you can put in that machine is non-tobacco products. Let's say we mix the two. And so you have a child who's 12 years old that goes over and makes a purchase. Then I think in those instances where a clerk it has to be in plain view of a clerk, you've added another dimension to their burden, and that is, wait a minute, I saw you buy something from that machine and I don't know what it was. Obviously, if that 12-year-old child approaches the vending machine to purchase something from it and the only thing in it is tobacco products, then I think you've created a situation where the clerk has to inquire or say, wait a minute, you can't purchase that. Somehow they intercede.
Thank you. Chairman Franklin?
Since I need to leave to go to another committee meeting, and if the proper time is in the next about 60 seconds, I'd like to be recognized to make a motion to pass.
I'll try to get back to you, but I don't want to cut off questioning. Representative Collins?
Yes, sir. I appreciate it. I have just a few questions here. And I apologize here. But then this attempt to purchase.
Could my motion stand on the table in case I have to leave?
I'll make the motion if it gets pulled off.
Oh, okay, thank you.
Under this attempt to purchase, and I know I know you had stated you were trying to catch multiple. Right now, currently, and just help me walk through this. I don't smoke, so I would just have to take your word at this. If someone under 18 attempts to buy a tobacco-related product, they have to be carded. If I see it at all the convenience stores, they have to be carded. If a person who is 17 walks up, he's carded, he's obviously not 18, the clerk says, no, we can't sell this. At that point in time, would this bill say that even his attempt, even showing ID proper, not fraudulent ID, he would be guilty of a misdemeanor?
Well, I don't know that the law requires they be carded. I think that's a practice of the industry. The law requires they can't be 18 or more. But perhaps what this bill goes at is this, and this is what retailers have told us, is that the minors will make attempts over and over and over again, and eventually they'll become successful. What the attempt in and of itself, though, is hard for them to say, wait a minute, this is a violation of the law. They can't. Frankly, I think it's tough to put it in signage, if you want to know the truth.
Okay.
That the attempt is a violation of the law.
All right. I understand. Mr. Chairman, I have permission to follow up.
Sure.
Okay. I understand what you're saying, but however, if I am told that I cannot sell something to someone under age 18, then I either have telepathy to know that this person is not 18, or I have to card.
Sure.
So it's the same way would be for alcohol. So I guess what I'm just curious in, and just to clarify, that even if a person presents a non-fraudulent ID card, they're just being stupid, they stand up, they're under 18. This would say at that point, now, would the clerk call the police at that point? I understand the intent. Please don't. I'm not trying to tear this down, but I'm concerned that we're making something here that's more difficult than it could be.
I asked the same question. I'm walking through the logistics of this. I'm not sure the clerk calls the police. I really don't know that happens on every instance when someone under 18 comes up and attempts to purchase the tobacco product. The law now, this really does not change the law. The law now is it's a violation of the law to make that same attempt. What I do think happens, though, is by clarifying the law and adding the words attempt to purchase, is it now becomes easier for retailers to message that fact. Your attempt is a violation of the law. Currently, the law says the same thing.
Currently, the law says right now a purchase is against the law, not an attempt.
Well, if you attempt to do something that, if completed, were a violation of the law, that attempt
And
is a
that may be
violation.
where this legislation is leading to, and that's what I.
Yeah.
Okay. That's all. Again, I think the logistics is what I'm trying to get.
No, yeah,
my
and
head here.
I'm with you. I'm with you on that. I think it's probably more about a message than it is about actual enforcement. Although, if you have a minor who continues to make these attempts, I think there probably would be those cases where you'd see some enforcement.
Okay. All right. Thank you, Mr. Chairman.
Thank you.
Secretary Bearden and then Representative Levitas.
I believe Representative Collins is on the right track. I believe they are required to ID.
Are they?
If I'm not
Perhaps.
mistaken, I believe they are, so he may have a very good valid point. Now, is this bill, are you strictly trying to deal with vending machines on this? Or are we looking at the whole spectrum?
I'm not sure if I understand your question.
Is this bill trying to solely go with the vending machines? Or are you just trying to say anyone at any given time? Because that will bring into play his question. If someone tries to buy tobacco and they're 17, are they then in violation of law? And also could be charged as misdemeanor for attempting to purchase.
They'd be in violation now if they tried that. I mean, that's my point, is that we're not changing that area of the law. If you're 17 and you go up there and you hand them a license and the clerk says you're 17, you can't buy this, they're in violation of the law now.
But the new language is attempt to purchase it.
It does-
Am I missing something on this?
We're simply making that part of the law easier for retailers to message to the public.
I'm not sure they'd be against it.
Hang on one second. Are you finished?
Yes.
Representative Levitas and then Representative Collins. Okay. Representative Levitas. I'm sorry, Representative Collins.
And I think just as a follow-up, the code section, which that's why I picked up the code section, 1612-171 deals with over-the-counter purchases. Okay, 1612-173 deals with machines. So
Right.
that was why I think, and I understand, again, I'm not to be argumentative, I was just trying to clarify this because at this point because I asked the question of even Representative Bearden, if someone and I haven't checked the alcohol laws, that if you present and you're just turned down, I guess that's my problem here that
Yeah.
I'm struggling with. If a clerk does their job, which they're supposed to do to make sure this child is not 18, or purchasing, and they turn them down, at this point in time, that child, I'm just is this making them all, at that point, they're turned down, they can't purchase it, we've now said, through attempt, they've committed a misdemeanor.
Yeah, and I don't know the answer to your question. I think what happens in the case of alcohol is if they present the license, they make the attempt, it's clear on the face of the license that they're not old enough to purchase the alcohol. I think the license is seized at that point, but I may be wrong.
Okay, but not in tobacco fine, and this is what we're dealing with.
No, we're
tobacco.
certainly not saying that's what we want to do here.
Okay.
Yeah, and that's the driving, maybe to answer both your question and Representative Bearden's question. The driving force behind the bill was to clarify the situation of vending machines.
Okay.
What we've heard from retailers, though, is it's difficult for us to message the fact that this attempt is a violation of the law. We want to be able to do that.
Okay. So, pardon me, but you just said, you just said that your whole purpose was to get the vending machine clarified, and now we've added we've added that one, and I understand that we've added that attempt to purchase into the over-the-counter issue.
Well, that was in we didn't add it. It was part of the original legislation as introduced. But what I'm saying is that when we first started discussing the issue, it was vending machines that was the driving impetus behind creation of legislation in the first place.
Okay. Mr. Chairman, I don't want to stand in the way. I think we're just a semantic issue here that I'm not sure we're at the same point, but I appreciate it. Thank you.
I'll come back to you if you'd like me to.
I'm okay, I think.
Representative Levitas. Who? Yes. Okay, help us. Right.
That's really all we're trying to do, Mr. Chairman.
Does that help you some?
It's fine, sir. Thank you.
Okay. Further questions for the author? Further questions? Did you have an amendment? Okay. Further questions for the next year? You have an amendment? There may not be a bill.
I don't think Chairman
Again, there may
Moffitt
be. You never know. Further questions? Recognize Representative Levitas for a motion.
Mr. Chairman, I would move pass.
Second.
We have a motion that Senate Bill 95 be given a due pass recommendation. Is there any discussion on the motion? Any discussion on the motion? Hearing none, all in favor of the motion, please indicate by raising your right hands. All opposed, same indication. Would you, are you leaving now?
Yes, sir, Mr. Chairman, unless you'd like for me to stay.
No, that's fine, but would you take this news upstairs?
I'll be happy to.
Thank you very much.
I certainly will. It really does make a difference. Thank you, Mr. Chairman.
Thank you. Central State, Senate Bill 24.
Good
Glad to have
afternoon.
you with us today.
Thank you very much. I appreciate your hearing this bill. In fact, I appreciate the work you've already done on it. I was out of the country, I think, when you met last, and this went to subcommittee. Just a few remarks about Senate Bill 24 that I'm sure most of you will remember. This is the second time this bill has been around. We had it last year, vetted through the Senate Science and Technology Committee, and then you were kind enough to work on it last year. It passed and was in House Rules, and we just didn't get it onto the floor at the end of the session last year. So I'm bringing it back again this year. As chairman of the Senate Science and Technology Committee, one of the things that I'm interested in as I attend meetings, NCSL and ALEC and others, is to look at what states are doing about the criminal use of technology. Certainly phishing scams, as they've come to be called, one of the major problems out there. We all get these emails that look as though they may be coming from eBay or our bank or another institution that we have an account with, and they're actually just scams trying to get us to go to a website which is false. It violates the trademarks of corporations. It implies that it is another entity, a legitimate business entity, but it's really just trying to get our personal financial information. So this is something that the GBI and many of internet service providers and businesses who are being scammed, as well as the individuals who do fall for these things. It's a bill that we believe we need to have on our books in the state of Georgia, so that when this kind of thing takes place in our state and we can get to the individuals that are involved in these crimes, we will have protection in order to go against them. So that's sort of just the basic background. We've been through this before. Obviously, this provides a means for either the individuals who may be defrauded as a result of these scams, or the companies whose trademarks are being violated, or others to be able to go after these criminals. There are obviously both civil and criminal penalties here and actions that can be taken. I'd be glad to answer any questions about that. I would just like to say, Mr. Chairman, it's my understanding that the bill that I brought to you this year was the bill that was approved last year by your committee and the subcommittee, I believe Chairman Knox may have chaired, that took a look at the bill last year. So we brought it back. It's my understanding that your subcommittee only added the word prior in 3 places in dealing with what I know is a very important legal concept of knowledge. What does it mean to say that an employer has knowledge of what may be done with their computer equipment by employees? And I would like to say that last year we took a very careful look at what that word meant, and I think everyone was pretty satisfied with that. But this year, it's my understanding you've added the word prior knowledge, and I'd just like to say I don't have any real problems with that. I think we are trying to strike a balance here to protect employers when legitimately they don't have knowledge of what their employees may be doing with this equipment, and yet also protect those where perhaps employers do have knowledge and don't take any action. So I'm comfortable with the way the subcommittee has made those changes by inserting the word prior. I'd be glad to answer any questions, but hopefully it's a bill that we can get to the floor this year.
Questions for the author? Representative Lapidus.
Yes.
Thank you for being here, and I appreciate this bill, and I certainly think dealing with the issue of fishing, and when we talk about it sometimes, and it comes up at a company, my company, from time to time, we're dealing with what we call the minnows, and different theories on how to deal with them, as opposed to us who are the management of the company, and how has your bill addressed that? Is there any changes between, so I was familiar with it last year also, has it changed in terms of how it addresses what we would call the minnows versus the ones that are having to watch the minnows, that whole theory of the minnows?
No, I think the bill is essentially as it was last year. I don't think, in fact, there are any other changes, substantive or even minor, from where we ended last year with the particular bill. I mean, obviously, we want to get to the perpetrators, the individuals who are doing this, and it's not easy to do, frankly, because many times they are, they're in other states where our jurisdiction does not reach. They're sometimes in other countries. But what this is meant to do is hopefully just get us to the point that if we can in Georgia find a perpetrator, an individual, or if it happens to be a business doing it, though one tends to think of this as being individuals, that we have the ability to do so with proper protections for companies that may have this going on by an employee or someone with access to their computers without their knowledge. I think we've tried to be sensitive to that here. Where the line is obviously an important question here, but I think going from employers' knowledge to employers' prior knowledge is a further help in drawing that line.
Thank you. Appreciate the senator being here. Thank you, Mr. Chairman.
Any further questions? Representative Byrd. What's your amendment?
As opposed to prior knowledge, should be actual knowledge.
I've looked at that, and I think that might improve it. And go to about 3 places on that page, I think.
That's correct.
Did you want to be heard on this? On this bill?
I'd like to speak to that.
Okay, well, she hadn't made it yet. I'm just trying to find out what it might be. Any other questions for the senator?
Mr. Chairman.
Any other questions for the author?
I'm just trying to figure out where the
Representative Beard.
Page 3, line 24, where it says prior knowledge. Line 27 and line 30.
I realize I'm not the person asking the questions, but could someone help me understand what that would do as opposed to prior? Are you inserting that along with prior, or in addition to prior, before prior, after prior?
I'd like to speak to that proposal at the appropriate time, Mr. Chairman.
Let's hear from Mr. Clark first. You'll just stay with us,
Certainly.
Senator. Did anyone else want to be heard on this bill?
I would like to speak on it, Mr.
Okay.
Chairman, if possible.
All right, let me recognize Mr. Clark, and then Mr. Reese, I'll come to you next.
Here, Mr.
Bill
Chairman.
Clark with Georgia Trial Lawyers Association.
Thank you, Mr. Chairman. Bill Clark on behalf of the Georgia Trial Lawyers Association. We support Senate Bill 24 and commend Senator Staten for bringing this very pro-consumer law bill for both allowing criminal prosecution of those who would engage in phishing, as well as those who would want to seek a remedy of their own rather than requiring law enforcement to do it, and certainly in cases where law enforcement can't, to bring a civil action for the harm that's done to them through this phishing. The subcommittee met, and we've been talking with the business community on this bill and on the specific issue that is raised by Representative Byrd's amendment. We've been talking about knowledge and the culpability for that knowledge for about 10 weeks now, going back to early discussions in the bill over on the other side, on the other chamber. And this morning, for the first time, they asked for actual knowledge. Understand that, and I know you do, but this is the difference between actual knowledge, meaning they knew that their employee was engaging in a criminal act. If you accept Representative Byrd's amendment, you're saying the only instance where an employer can be held civilly or criminally liable is if they had actual knowledge of that criminal activity going on. We, by that amendment, completely eliminate liability for constructive knowledge, where an employer, because of their ability and responsibility for the acts of their employees, they can be held accountable. But this amendment says the employer can turn a blind eye to their employees' work, and as long as I don't know about it, I'm not going to be held responsible for it. I don't believe that's the appropriate public policy that this committee has stood for and that the legislature should stand for. It is a public policy question. I think putting the word prior, and it's why we were in agreement with it, we thought it struck a good balance. You still would hold employers responsible at in appropriate circumstances, but you wouldn't let them just turn a blind eye to what their employees were doing back in some cubicle with their computer that you would never have any responsibility for unless you went back there and watched them and saw them doing the criminal act. If they were selling drugs out of the back of your warehouse, you're going to be held responsible for constructive knowledge of that. If they were robbing your clients, your customers, if they were stealing from your customers, they're going to be held accountable for that constructive knowledge, for constructively knowing about that activity, and we believe they should be here. I'll be glad to answer any questions. It's a tough public policy question, and it's a fair-minded debate. I wish we had had the opportunity to discuss actual knowledge coming from the business community over the last 8 to 10 weeks instead of over the last 2 to 3 hours, but they were good enough to tell us this morning that that would be an amendment they were seeking today, and I'm glad to answer any questions that you may have.
Vice Chairman Mumford.
I have a question and then a follow-up. Mr. Chairman, is that all right?
Yes, and then Representative Benfield.
The purpose of putting the word prior in here is because obviously there may be someone, some corporation that may find out they've had a rogue employee who sent out emails, and they find out after the fact, and if they didn't know about it beforehand, they wouldn't be responsible. That's why we put in the word prior. Is that correct?
That was the concern that the business community raised with us, and we felt, particularly in still relatively new technology, that was an appropriate accommodation to them, to say that we're not going to look after the fact and say, okay, you know about it after the fact, now you're liable.
But one of the concerns is that where you have, obviously knowledge can be proved by circumstantial evidence.
That's correct.
You might have a company that's, you know, in the business of selling widgets and is an actual widget manufacturer and sells widgets, correct?
Yes, sir.
And if some employee was sending out some kind of a fish that didn't have anything to do with the sale of widgets, then it would be pretty clear that the company may not have any knowledge of that. Is that right? You'd have to produce evidence to show that that they had some knowledge.
You would have to produce not evidence that they knew about it, or that in the reasonable exercise of their business, that it would be reasonable for them to have conducted themselves in such a way that they could have found out. In fact, that they should have found out. And these are subjective standards. I'd love to have a standard for every type of business, but different types of widget businesses would call for different
May I continue
standards.
to follow up?
Yes.
The problem that I see with the term actual is if you have a company that's in the business of illegally fishing on the internet, and that is their sole trade, their stock and trade, if we put the word actual in here and you arrest the guy that hit the button and sent the email, his boss sitting in the next room could say, I didn't know he sent it.
That's right.
And he would walk.
That's right.
Thank you.
Representative Benfield.
Oh, thank you. Representative Mumford answered. He asked most of my questions. Basically, I was trying to understand how you would even go about proving actual knowledge. It seems like an incredibly high standard, and Representative Mumford did make some very good concrete examples. That helped clarify it for me. But if you have any other I mean, how would you even go about proving that the employer actually knew what the employee was doing?
The constructive knowledge case law is very fact specific, and what the courts are usually looking for is, did the employer do something in the ordinary course of their business, or did they depart from that? Did they fail to do something that was a routine part of their business? And if they didn't do those things which you would expect them to do, and they just turned the blind eye, then they're going to be held responsible. An easier example, although maybe not more illustrative of the point, is in a different context, and that is premises liability, where a premises owner can be held accountable not only if they knew there was a big hole in the property that someone could step in, but if they should have known. And the courts say you're going to be responsible because you have possession of that property and an opportunity to discover that danger more so than those whom you would invite on the property. And so the law says, we're going to hold you accountable because you are in a better position to protect your invitees, your guests, than they are. I would submit to you that this is similar. The business owner is in a better position to protect its customers and others from harm that their employees would engage in. And so the law should hold them accountable when they fail to do that.
Representative Levitas.
Can you reconcile for me the level of responsibility that an employer might have? In other words, would an employer like my company be required to monitor internet use? Would that be a standard that you would see if the constructive versus actual knowledge standard is there?
I don't know enough about your business.
Generic business.
The reason it's difficult to answer the question is because constructive knowledge cases almost always turn on the specific facts. It does make it more difficult. It is a subjective standard, and so that makes it more difficult. But the law says, and the public policy argument would be, that because you are in the best position to know what risks your employees create, you're in the best position to protect others from the harm that would come from that risk. And so it is subjective, and it's going to be fact specific. I wish there were a better way to define standard by standard for each type of business. The case books, the code books would be extremely long if we had to do that, though.
Can I ask just one follow-up, Mr. Chairman?
Sure.
And I guess that leads me to the next question. With Representative Mumford's example, obviously, or to me obviously, if a company is engaged in the job of fishing, then they're going to have actual knowledge that fishing goes on. And in the criminal law, as I understand it, it's not the intent to cause the harm, it's the intent to do the act that results in the harm. So if somebody was engaged, their firm is a fishing firm, then it would seem to me that if they all have actual knowledge that that's what folks are doing, whether or not they have the specific intent to fire the button, then they would have actual knowledge. And I mean, again, that's hopefully it's such a small 1 or 2 or 10 person business, but I don't think that would provide them with escape from liability. Do you?
probably not from criminal liability, and I'm, as a former prosecutor, you know criminal law far better than I do, so I won't even...
Some of my former colleagues might challenge you on that, but thank you for saying it.
Well, amongst this group, I'll say that that I believe that you know what you're talking about in that area, so I don't doubt that at all.
Thank you. Thank you, Mr. Chairman.
Further questions? Thank you, Mr. Clark. Recognize
Chairman,
Mr.
members
Reese
of the
now.
committee.
Thank you, Chairman Ralston and members of this committee. I, too, would like to commend Chairman Staton for bringing this piece of legislation that could help curtail a real problem here in the state that robs Georgians of so much time and potential money on an everyday basis. By all means, the members of the Georgia Chamber of Commerce support prosecuting criminals to the fullest extent of the law. If a company has a rogue employee, however, that is smart enough to do these types of email phishing schemes, then he or she is likely smart enough to be able to devise a way to work around the company's ways of monitoring emails and things like that as well. So we're pretty worried about that. We feel like there's no reason to create a new cause of action in this instance, and that's mainly because Georgia businesses are doing all they can right now to prevent these types of things, and technology is getting better all the time. Our member companies have a reputation to protect, and I feel like they're policing themselves pretty well and continue to improve. We did ask our business members which term they were more comfortable with, prior knowledge or actual knowledge.
Let me jump in there, Mr. Reese. When did you do that?
That's been about 2 weeks ago.
Okay. Was it prior, to be redundant, was it prior to passage in the Senate?
Mr. Chairman, we had asked them to take a look at the bill, and in fact, I'd have to disagree with Mr. Clark. We have been working with members of the legislature and staffers through this whole process. I did give him the respect this morning to let him know that we were going to have to work on the bill a little bit for our members to be comfortable with it. I think that's what he's telling members of the committee. But our members did prefer and were more comfortable with the term actual knowledge because, according to them, that means that they really knew. And that's all they want. That if businesses need to be punished for these crimes and they really knew about it, by all means, we feel like they should be held liable. But we don't feel like that they should.
How do you prove that?
I don't know about that,
okay,
Mr. Chairman.
Okay.
But we want to go after the criminals. Mm-hmm. We don't want to go after the companies because perhaps they have a deeper pocket. A factor that we worry about additionally is people logging in to the company network. People not even connected with the company at all. They could be out of state or even out of country. Rogue criminals not even connected with the company in any manner. Phishing's bad, but I feel like we need to go after the criminals, not create a new cause of action against business.
Okay.
And I would ask for your consideration on the amendment.
Representative Abrams and then Representative Byrd.
Thank you, Mr. Reese. I have a couple of questions. Can you tell me why prior knowledge creates a concern?
Representative Abrams, I can't tell you that, but I'm only here as a representative of Georgia businesses, and that's what they told us. So I'm bringing that to you today.
And is it, I guess, and this again goes to whether you can speak to this or not. The other question I have is whether or not it's the assertion of the Georgia Chamber of Commerce that there are no businesses that engage in the act of phishing, that it's only individuals. Because I think that creates a very different dynamic if you're talking about rogue individuals doing it as opposed to companies that engage in the act of phishing because it is useful to their business to get information. Does the Chamber believe that there are no businesses that engage in the act of phishing?
I think businesses do engage in the act of phishing, and I'm confident that's a crime under current statute.
And so you believe that the employers who hire these persons should not be allowed to escape responsibility by creating a false shield between themselves and their employees?
We don't want to shield anybody who's committing a crime.
Thank you.
Representative Byrd.
Yes, that's and not being an attorney, prove prior knowledge also? I mean,
I'm getting my jacket tugged in. I'm going to let Vice Chairman Mumford take a shot at answering that for you.
all right.
Let me try and answer that question by reversing it. How do you prove actual knowledge? In order to prove actual knowledge, you've got to come into court and have somebody testify that I saw Mr. Mumford and Mr. Ralston talking, and Mr. Mumford told Mr. Ralston to send those fish. And those fish were whatever XYZ fish that we're talking about. Or you're going to have circumstantial, or you're going to have some other direct evidence. It could be documentary. The letter I sent to Mr. Ralston telling him to send those fish. That's what actual knowledge is going to require. It's going to require very strong direct testimony. Knowledge is a strong word. We're not looking to get people who are innocent. And if you've got a rogue employee who is sending emails and you don't know about it, you're not going to be caught in this net. If you have a rogue employee that's sending fish and somebody comes to you and says, we got a zillion fish here, and you say, well, I don't care, and you let it keep going and they keep sending the fish, then you might have a problem. If you've got somebody who's coming from outside and logging into your server and sending fish, you're not responsible for that. You're the victim. You didn't know about it. That's what knowledge means. And the reason that the word prior was put in here was to make sure that we're not going to pick up somebody because one of your employees sent a gazillion fish out. They were obviously, it was found out after it happened. They come in and tell you about it. If you didn't know about it before they sent it, you're not going to be criminally responsible. So this is it seems like a very small matter, but I would suggest that putting the word actual in here is going to limit any efficacy of this statute so that it is meaningless.
So I'd like to respond. So then that means in the days when presidents had said they have no prior knowledge, were any of them ever convicted or were they charged?
Well, there's a lot of presidents, I don't know about no prior knowledge, there's a lot, well,
There's
a lot of folks that,
they always.
well, I will tell you this, in
knowledge.
criminal prosecutions, it is not unusual for people to have very severe memory lapses.
Case in point.
Chairman Cooper.
Forgot my question.
I'm glad I had that effect on you.
No, she just remembered it.
I
Okay,
just
Chairman
remembered
Cooper.
what it is. Okay. The gentleman that testified for the trial lawyers, though, said that if you should have known it, so I mean, if I have a company full of employees using a computer, and I've got a couple of employees doing this or one doing it, here again, am I supposed to be, am I going to be guilty if I haven't had some kind of check and haven't been making periodic checks on their computer or something of what
Well,
they...
I don't want to argue with my esteemed fellow attorney,
No.
Mr. Clark.
Oh, okay.
But I would say this statute doesn't say knew or should have known. What it says is prior knowledge. Now, I think what he was getting at, there reaches a point with circumstantial evidence where it may, if it establishes prior knowledge, it may not be direct evidence. I mean, you've got a company that's in the business of fishing. You've got 20 employees and they're all doing the same thing in the same way with different schemes and scams. One of the employees tells you that he was told by his employer to do that, and 19 others went back to Mexico or wherever they came from and are unavailable. That might be sufficient evidence to prove prior knowledge, or that they should have known based on all of the circumstances. But this requires prior knowledge to be proved.
So you don't...
If you require actual knowledge, you're going to have a smoking gun, a witness who is saying, he told me to do it.
But you don't...
Isn't prior knowledge also involved in dog biting cases?
Well,
You'd have to, I got a great bill.
no. Well, actually, it's
In the body of law? of dog bites?
currently in Georgia, it's my understanding there is no free bite, so you're not entitled to prior knowledge that your dog is prone to bite, contrary to popular belief.
Representative Lewis.
Again, while Representative Mumford hates to disagree with his colleague, I hate to disagree with Representative and Vice Chairman Mumford, but I think it's certainly possible that one can have prior constructive knowledge. I don't think that prior deals with the word constructive at all. In other words, I think, so I don't know that okay. So, and I guess I would further challenge the assertion that no one's going to be caught in the net. This goes back to my question of what would be the appropriate standard for monitoring. In other words, if your server's attached, and I don't know if your folks, and I do think, I will say this, as you know, I'm a business person, I support business. I do wish that we were dealing with this where the trial attorneys in the business community had a chance to work on it. I wish that it weren't 2 hours before when Mr. Clark was told about this, because it makes it a lot easier for us if y'all are on the same page and y'all have had time to work it out. That said, I don't want to rush through this either with changing it to be a bill that may have unintended consequences. And one of my concerns, as you probably picked up from my questions to Mr. Clark, were the burden that's going to be put on employers. And I guess I'd ask, I don't know if this came up with your employers, and this would probably be a question I'd ask to Mr. Clark as well, is how does the scope of a person's duty for the company affected by this? In other words, my particular business, we do cleaning products. That's what folks manufacture and sell. There is no part of that person's job description that involves fishing or anything like that, and we would fire somebody if we knew that it was going on. And I guess my question is, do y'all have any, in your discussions up to this point, did y'all discuss scope of duty in terms of the liability that an employer would face? And if we don't go with actual knowledge, how would that affect? And I'd really like, Mr. Chairman, if I could, to ask that of both witnesses and the bill's sponsor, if it's appropriate.
No, sir, Representative Levitas, we have not had those types of discussions, but I don't believe that there is a uniform system that our business members are having to follow at this point. I can tell you that every day I believe they're having to do more and more things that perhaps do invade the privacy of an employee in a way that a business does not like to do. But the reason that the businesses are having to do that is to prevent these types of activities, these illegal fishing things, and I can't imagine why they would not continue to move forward preventing crimes such as these. But it is a good question and a discussion that our members ought to have.
Representative
Thank
Collins.
you, Mr. Chairman.
I appreciate that. I know this has come through subcommittee, but it came to your subcommittee, correct? Now, when it came to you, it had prior in the language when it came to you. Is this the way it came out?
I'm not sure. We may have added the word prior.
I think you added
to try because of concern that about knowledge.
Okay.
To make sure that it was prior, not after the fact.
Or constructive.
Well, constructive is included in the word knowledge in mine.
Yeah. Well. Okay.
Knowledge does not have to be proved, just like the word actual. Knowledge can be proved circumstantially and directly.
Right. I agree. Okay. And that was my question as I was going through this. So it came, Senator, it came to us as without the employer's knowledge, consent, approval. There was no other.
It was approved last year, so prior is an addition this year through the subcommittees.
Okay.
And prior was a word that was chosen because it did not. Actual was discussed. We knew that actual had been talked about, and it's certainly my view that actual severely limits this.
So if I think
prior was an effort to get somewhere a little further down the road, but not to actual.
as we were sort of talking here, I think the question is coming up, and I understand. I think where we're at prior in interpretation of how from a seeming legal interpretation here would be prior would be knowledge before the act occurred.
That's right.
All right. Actual knowledge is knowing the act's occurring, whether you knew it was after or before.
Right.
Okay. I'm going to let it go with that.
Well, here's what I'm.
Because where I'm heading is a different place, but I think you understand
Any further questions real quick for the author or either of the two witnesses? 'Cause I think what we're going to do is this. Mr. Clark indicated that there had not been adequate time to have some dialogue between the various groups, and it occurs to me that we do have the luxury at this point in the session to have a little bit more time. So what I'm going to do is to ask Mr. Reese, you and your group, to get together with Mr. Clark. We're going to, Chair's going to exercise its discretion to put this on the table until our next meeting on Monday afternoon, April 9, to see if that can be resolved. If it cannot be resolved at that point in time, it's my intention to, shortly after we convene, to recognize Representative Byrd for the amendment that she was wanting to offer today, and we'll, if she still desires to offer it, we'll take it up and see what the will of the committee is. But if there hasn't been adequate time for whatever reason for y'all to explore a resolution of this between the two viewpoints, then we'll give you that opportunity. And does that meet with your approval? Okay. Okay, thank you very much. We have nothing else on for today. We'll stand adjourned until Monday, April the 9th at 2 p.m. This bill will be on the committee, or on the